My dear students, moving on to the next lecture, which relates to right to equality. This chapter of right to equality starts from Article 14 and it will end at Article 18. So, Article 14 to 18 of Constitution of India constitute right to equality. Article 14, as we have read earlier also, enshrines the principle equality before law. All are equal before law. Right from Prime Minister to ordinary citizen, all are equal before law. Hence, Article 14 says it has two parts. Number one, the state shall not deny to any person equality before the law. This portion of Article 14 is taken from English common law. And second part is equal protection of the laws within the territory of India. And this second portion of Article 14 is taken from Section 1 of 14th Amendment of American Constitution. So in Article 14, equality is divided into two parts. One, the state shall not deny to any person equality before the law. And second portion, equal protection of the laws within the territory of India. This right to equality, dear students, is not merely a negative right, not to be discriminated against, but also a positive right to be treated as equal. The second expression of equality, as I told you, is corollary to the first expression. And it is difficult to imagine any violation of equal protection of the laws, which would not be a violation of equality before the law. And the word law, used in the former expression of Article 14, is used in a generic sense or philosophical sense. Whereas the word laws in the second expression denotes specific laws. First expression, all are equal before law. So here law means a philosophical sense of the law. And in the second expression, the state shall not deny equal protection of the laws. Here the law denotes specific law. So right to equality is also recognized as one of the basic features of Constitution of India. And this was held in Indira Sahni versus Union of India. That equality clause, right to equality, is a basic feature of Constitution of India. And the latest position of law is that Parliament can amend any law, Parliament can amend any part of Constitution of India, but they cannot amend basic features of Constitution of India. So Article 14 cannot be amended, cannot be changed by the Parliament. And this Article 14 applies to all persons and is not limited to citizens only. Because the words of Article 14 say that state shall not deny to any person. Any person means even foreigner, including the citizens. Dear students, you will wonder, what is the underlying principle of equality? The underlying idea of whole of the chapter of right to equality is that likes should be treated alike and unlikes should not be treated alike. This is not a jugglery of words. It is a real import, real meaning of equality. that likes should be treated alike. जो एक समान है उनको आप समान व्यवहार दीजिए, समान ट्रीटमेंट दीजिए, लेकिन जो समान नहीं है उनको आप समान ट्रीटमेंट देंगे तो वो इनइक्वालिटी हो जाएगी. I used to give this illustration all the time while teaching equality. That suppose in your home your father is ill, he is suffering from temperature, loose motions also. Rest of the family members are okay. So doctor has prescribed very light food for the ill person. तो भाई इसको खिचड़ी खिलाओ, दाल चावल खिलाओ. But other healthy persons are not ready to teach that khichdi or dal chawal. They say why we should? हम तो बटर चिकन खाएंगे, मखनी दाल खाएंगे. All right. See, ill person is a different category in your family. Healthy persons, they constitute a different category in your family. So if you will give heavy food to ill person, it will be unjust for him. And if you say that the food fit for ill person should be given to the healthy persons also, again it will be bad for them. So you treat different persons differently. If a person is ill in your family, his diet should be restricted. But not necessarily that you will force that diet on the healthy persons also. Because healthy persons, they are constituting a different class. So if there are 4 healthy persons, you can give same food to all the 4. But ill person is not like a healthy person. To ill person, you will have to give only that diet which doctor has prescribed. This is the meaning of likes should be treated alike. But unlikes should not be treated alike. This means that Article 14 prohibits class legislation, which is based upon reasonable grounds of distinction. A classification to be valid must not be arbitrary. And 2 tests are to be satisfied before a classification is declared to be valid under Article 14. First test is that if you are distinguishing 2 groups into different groups, then number 1, classification must be based on intelligible differentia. There should be some intelligent basis for classification, which distinguishes persons or things that are grouped together from others left out of the group. You say there is distinction between boys and girls. Then what is the intelligible differentia, which distinguishes boys from the girls? And this differentia must have a rational relation to this object sought to be achieved by the statute in question. I'll give you an example of Section 11 of Indian Contract Act to illustrate this jugglery of words. Section 11 of Indian Contract Act says that a minor cannot enter into a contract. Minor is incompetent to contract. And the leading authority, all of us have read, is Mohri Bibi versus Dharamdas Ghosh. This section 11 classifies 2 categories, minors and adults. आप पूछेंगे साहब, एक बच्चा जिसकी उम्र 17 साल 364 दिन है, माइनर है, he cannot make a valid contract. But overnight, next morning, he turns adult. 18 साल पूरे हो गए. Now he can enter into a valid contract. तो एक ही रात में कौन सा जादू हो गया? One night before he was minor, and in the morning he became adult. 18 साल पूरे हो गए. So the basis of classification between a minor and major is age. And this basis obviously has a relation to the capacity to enter into contract. Minor does not have a capacity. बच्चा तो बच्चा ही है. So basis is the age, and this basis has relation with the capacity to enter into contract. The section therefore satisfies both the requirement of a valid classification. You cannot say that minor and major category is violative of Article 14. आप सबको क्यों नहीं कॉन्ट्रैक्ट का राइट देते? माइनर को क्यों रोक लिया आपने? Yes, इसलिए रोका because his age is less, his capacity, his mental understanding is less as compared to a major. For the same reasons, dear students, you know that lawyers, doctors, drivers, miners, and companies, they are subject to special legislations. You want to become a lawyer, you should have a degree of BA LLB or BBA LLB. You can say why you are distinguishing us from others. Anybody can join the profession of lawyer. No. Two categories of persons, lawyers and non-lawyers, are different. If you want to practice as a doctor, you need a degree of MBBS minimum. If you are a driver, you need a license. And likewise, minor and major, they are subject to special legislations. For minors, we have Juvenile Justice Act. Previously, Children Act was there. Now we have Juvenile Justice Act, giving different kind of treatment, different kind of trial procedure for juveniles. आप कहेंगे साहब आपने दो लॉ बना दिए, जुवेनाइल के लिए अलग, आम आदमी के लिए अलग. Yes, बनाए हैं. Why? Because juvenile constitute a different class. They are immature. And adult offenders, they constitute a different class. So this division is not violative of equality clause in Article 14. See, the object of classification should also be lawful. If you are distinguishing between two classes, then object of classification should be lawful and it should be made in good faith. A law may be constitutional even though it relates to a single individual on account of some special circumstances, not applicable to others. That a single individual may be treated as a class in himself. आप कहें कैसे साहब? एक अकेले आदमी को आप डिफरेंट ट्रीटमेंट दे रहे हैं और ये कह रहे हैं that particular individual may be treated as a class in itself. So on this point, we have a very important leading case, Chiranji Chaudhary versus Union of India. In this case, the mill on account of mismanagement was taken over by the central government under Sholapur Spinning and Weaving Company, Emergency Provisions Act 1950. The central government had overtaken this mill. Now the shareholders could not appoint a new director and could not take participation in winding up of the company because after takeover, central government will do these works. The contention of Mr. Chaudhary was that this act has infringed the rule of equal protection of laws under Article 14 because a single company and the shareholders thereof were being subjected to a disability vis-a-vis other companies and their shareholders. But Supreme Court dismissed the petition and held that the legislation was valid on account of special circumstances or reasons applicable to him and not applicable to others, may treat that single individual as a class. The Sholapur company formed a class in itself, hence the act was within purview of Article 14. Because the company was sick, and sick person is to be given a different treatment than a healthy person. That's why Supreme Court said it is not violative of Article 14. This act is not violative of Article 14 because it is giving different treatment to different categories of mills. A mill which is healthy, earning profits is different. But Sholapur mill going into the losses is a different class in itself. Maybe that Sholapur was the only illustration at that time. And now other companies might have fallen in this sick category. So, this distinction between sick units and healthy units is not violative of Article 14. And as we have studied in earlier lectures also, that whenever you test the validity of any law, there is always a presumption in favor of constitutionality of an enactment, and the burden is upon him who attacks it to show that there has been clear violation of Article 14. The prohibition of Article 14 extends to procedural inequality also. Equality is also of two types. One is substantive equality and second is procedural inequality. So Article 14 encompasses substantive as well as procedural inequality both. Another illustration before you is State of West Bengal versus Anwar Ali Sarkar. Daku Anwar Ali Sarkar, big dacoit. Special courts were created along with special procedure for trial of Anwar Ali and others under West Bengal Special Courts Act. Why you have created special court only for Anwar Ali Sarkar and his party? Special courts, special procedure. Why? For speedier trial of certain offences. And the procedure under this act was disadvantageous to the accused as compared to regular procedure provided in CRPC. Supreme Court decided that this act, West Bengal Special Courts Act 1950, is violative and ultra vires of Article 14 because the act did not indicate the class of persons who could be made subject to procedures set out in the act, meaning thereby an act which does not disclose the basis of classification is violative of Article 14. आपने अनवर अली सरकार के लिए स्पेशल कोर्ट क्यों बनाई? स्पेशल प्रोसीजर क्यों प्रिस्क्राइब किया? कोई रीजन, कोई कारण, कोई क्लासिफिकेशन, कोई रैशनल बेसिस? None. Hence, this whole of the act was declared as ultra vires and violative of equality clause given in our constitution. So the classification can be made according to the nature of persons, like distinction between public officials and non-officials under section 197 CRPC. You know, whenever a criminal case is to be launched against a public servant for the acts done in discharge of their official duties, a special sanction of the state government has to be taken. But for ordinary persons, no such sanction is required. So you have divided criminals into two portions. One, a person committing crime while he is a public servant during discharge of his official duties. And secondly, normal citizens. So for public servants, you need sanction of the government, whereas no sanction is necessary for prosecution of a private person. So this distinction, this classification between a public servant and an ordinary person is necessary to save the public servant from harassment. This is the object, that public servant may not be harassed unnecessarily by general public. So before launching a criminal proceedings against a public servant, section 197 CRPC says that you will have to take sanction of the government. Likewise, classification between civil population and military personnel is justified. And in prohibited areas, military personnel are exempted to consume wine also. So you have made 2%. Suppose on the China border, our military personnel are posted there. And that area is a dry area. Nobody can consume alcohol or wine in that area. But if you restrict your military personnel, they won't be able to do their job because they are standing in the snow round the clock. If you will not permit consumption of alcohol or wine for them, they will die. So 2 categories in the same area. Military personnel are allowed to consume alcohol. Ordinary citizen is not allowed. This classification is justified on the basis of their duties. Ordinary citizen can sleep in the night at home. आप रजाई ओढ़ के सो जाइए. But your military personnel who is standing overnight in ordinary clothes, surrounded by snow all around, he needs a different treatment. That's why you have permitted that military personnel are allowed to consume wines in such areas. Then, dear students, this classification can also be made according to nature of business. A higher amount of entertainment tax can be levied on cinema houses which contain large sitting accommodation and are situated in a fashionable and busy locality. The students of Noida must have visited Pacific Mall, Shipra Mall, where the number of visitors are more than a smaller cinema with less accommodation and situated in a locality where probability of visitors is less, like Galaxy Mall is a very small mall. So the difference in amount of entertainment tax, more tax on a larger cinema hall, lesser tax on smaller cinema hall is justified. Similarly, you see classification of films into category U for general public and category A for adults only is also reasonable. Otherwise, you can say why you have classified the film into 2 categories. One is for general public, another is for adults. The basis of classification is justified. That if film is meant for adults, having certain stories and pictures and scenes which a person in the category of minor should not see, he can go for U category movies but not for adults one. Only adults can see adult movies. तो आप कहेंगे साहब आपने adults और minors 2 classes बना दी, ये तो आर्टिकल 14 के अगेंस्ट हो गया, दोनों इक्वल होने चाहिए. No. You cannot give equal treatment to minors and adults. You will have to give different treatment to minors and adults. That is the correct meaning of equality. Then, dear students, this classification between 2 groups may be based with reference to time. I'll take one illustration of UP Rent Control Act, Act number 13 of 1972. For encouraging the construction of new houses, the UP Rent Control Act exempts the houses built within 40 years from the date of its operation. 40 साल तक मकान पर यूपी रेंट कंट्रोल एक्ट नहीं लगेगा, meaning thereby that landlord can let out that building at the rent agreed with the tenant. But after 40 years, the landlord has no right to let out the building. It is only the rent control officer who will allot the building to needy persons. अब आप कहेंगे साहब 2 कैटेगरी बना दी आपने, 40-year-old houses, more than 40 years and less than 40 years. Yes, this classification is also justified because the landlord who has spent, say, 2 crore amount in construction of the house, he should earn money from rental values. और अगर आप पहले दिन से ही उसको कहेंगे कि नहीं ये तो allotment will be done by the rent control officer. Then nobody will construct a new house. So this is an incentive for house owners that if age of the house is less than 40 years, then Rent Control Act will not apply and landlord has a liberty to rent it out at the rate he likes. But after 40 years, the same house, same landlord is not allowed to rent it out. The rental position will be adjusted only by the order of rent control officer. He will allot it to the needy person and he will fix the rate of rent also. So this classification is with reference to time. Less than 40-year-old houses and 40 and more years old houses. So dear students, the basis of classification is always important. And this basis of classification may be according to object of law also. I told you in the beginning that juvenile offenders are classified separately from adults and they are tried under Children Act 1960. Now Juvenile Justice Act has come into force. So in all such cases, the classification is a rational one and has a nexus with the object of the law to be enacted. That's all, dear students. Thank you.